University of Rzeszów. And it has been a great pleasure to introduce our today's guest, Professor Thiago Felipe Avanci from the Mackenzie Presbyterian University in Sao Paulo in Brazil. Professor Avanci takes part with me with the postdoc program about new technologies at the University Mediterranea in Reggio di Calabria. The new technologies will be the topic of our forthcoming student conference with some international guests. So if you have some students in Brazil, we are really open for cooperation. We'll discuss, of course, this matter after speech. So today, Professor Thiago Felipe Avanci will present a speech concerning Brazilian Supreme Court and major decisions on civil law. So, Thiago, the floor is yours.
Thank you very much, Professor Łukasiewicz, for your kind words. Thank you very much for your invitation. First of all, I'd like to say that I'm quite honored for being here with you for this class. Please extend my most sincere gratitude to University of Rzeszów for allowing me to be here with you for this class. It's earlier afternoon here in Brazil, but I guess it's a little later in Poland, late afternoon yet. And Professor Łukasiewicz, if I may so, please let your students be comfortable to ask anything if they don't understand something that I say in English for Brazilian institutes of law. Please, I am all ears for any doubts that your students may have. Okay, let's begin our class. I guess we can name it class. Let's begin our class having some considerations about some fundamentals of Brazilian legal system and Brazilian judiciary branch. Okay, let's begin with that so we can understand a little bit better about some cases that I've selected for you for this presentation. Okay, let's begin with a shared screen, if I may, please. Let's go. Okay, this is Brazilian Judiciary Branch 101. I'll try to be as shallow as I can, but some major informations we must to share with you so you can understand what are we dealing with. Okay, the first thing that we must realize is our STF role on the judiciary branch, on Brazilian judiciary branch. STF goes for Supremo Tribunal Federal in Portuguese, naturally. In English can be freely translated as Federal Supreme Court, something like that. And they are the highest hierarchy rank on our judiciary branch system, okay? They are the guardians of our Constitution, as it is mentioned on the Article 102 of Brazilian Constitution, okay? And they are our constitutional court, they are our Supreme Court, they are our final word on every case. And it's kind of important to understand and to realize that not all the cases reach STF, not all. We have every year about 100 million cases under deliberation, okay, in all courts in Brazil, and not all those reach STF. It would be impossible for they to decide it, okay. And naturally, also there is some requirements to reach STF in any level, and will not see every one of it, but as you can figure, as you can imagine, one major requirement is that specific case must be connected with somehow something connected, some matter connected with Brazilian Constitution. An interpretation problem or a specific problem with our constitutional text applied to that specific case. Okay, this is the first thing that you must realize. The second thing that you must realize is CNJ role on the Brazilian judiciary branch. Okay, STF has a judiciary, and it is part of the judiciary system. Okay, let's go. And CNJ goes for Conselho Nacional de Justiça in Portuguese, okay, National Council of Justice. It can be freely translated to English, and both CNJ and STF are part of our judiciary branch system. The major difference between CNJ and STF it's the following. STF has a jurisdictional function, a decision-making function. It means STF decides the cases that reach to them, okay? As a matter of fact, CNJ does not have this jurisdictional function, this decision-making function. CNJ goes for more administrative organism, a financial organism, a performance of judges, evaluator, and this kind of stuff. So there is this major difference, but they're both STF and CNJ. They are quite important on defining the major norms, the major rules that must be followed by every aspect of our state, our Brazilian state. Okay, this is the quite important for us to get. Nice. And the third thing that you must realize is the connection between civil law and fundamental law, which are going to allow us to discuss some civil law matters on a constitutional court as STF. Okay? Well, let's begin with the basics. Fundamental rights. With the concept of fundamental rights, I'll try to be as shallow as I can once more, but we can conceptualize fundamental rights as a constitutional rights which were born in a relation between state and people, defending people against the state on a vertical relation. Okay, this is quite important. But in the last 70, 50 years or so, there were an application of these fundamental rights in a relation between members of the society, okay, on a horizontal state, okay, on a horizontal level. This is quite important for us to understand and to realize all the ramifications of these matters. Because if you do understand that fundamental rights nowadays are applied on a horizontal level, on the discussion between two people on the society, you do get that these fundamental rights are naturally a projection or projector of the civil law itself, okay? So when we are talking about civil law in one state, we are talking about fundamental right at some aspects. This is quite important for us to understand that I don't know if all, but almost every major civil law aspects are a projection of a fundamental right in any level. Okay? Well, this is the basics, and let's begin our discussion with some cases that I've selected for you from now. We survived the introduction so far, and now we're going to discuss about the cases, okay, the cases that I've selected for you. And the first case that I've selected for you is ADY 4277 and APF 132. They're both judged by STF on May 5th of 2011. The matters of these cases are the same-sex union, the same-sex marriage, the same gender union marriage, okay? And before we talk about the matter itself, it's kind of mandatory for me to explain to you about the cases for themselves. Let me clarify for you what is ADY and what is ADPF. They're both a kind of class actions which are a variant of our constitutional review, our constitutional control. As you can figure, constitutional review are made by STF, mostly made by STF, and this kind of class action, the decision does not take into account a life of some particular person, but the decision goes for a normative, more generic normative and a legal consideration, as I've mentioned, more generic. This is kind of important for us to understand why this kind of action, why this kind of decisions are applied for everyone here in Brazil. There is no someone. Everyone are reached by the effects of this decision. This is quite important for us to understand the power, to understand the attributions of STF on this kind of role, okay? Keep this in mind. Considering this, when I, for instance, explain these matters on our regular graduation course or on our regular law school course, I try to explain to my students that the three regular branches, judiciary, legislative, and executive, there three have a major attribution, and this major attribution, as you can see, I guess it's worldwide the same, but this attribution for judiciary goes for decide the lives of the people who ask for help for this organ, okay? And the attribution of legislative goes for to create law, and the attribution of the executive goes for organize the life of the state itself. I guess it's the same worldwide, doesn't change so much. But with this main attribution, there is two secondary and tertiary attribution for those three branches. The judiciary branch does have a administrative attribution and does have a legislative attribution, and the same goes for legislative, does have a administrative attribution and does have a judiciary kind of attribution, and executive does have a legislative attribution and a judiciary kind of attribution, okay? I'll not go deep on these matters for time reasons, okay? We can talk about this another day, but when you do realize that judiciary branch does have a legislative attribution, secondary attribution, you start to get how far does this kind of judgment, the kind of decision can reach without without being an aggression of the balances between all those three branches, okay? So it's natural, it's on our constitution, it's something predicted on the checks and balances systems that our judiciary branch does have this kind of attribution to decide to decide this kind of constitutional review, and this decision are applied indeed for everyone here in Brazil. Okay, once you do understand these matters, let's go to understand now the content of the decision. Okay, let's go for that. Let's discuss now the content of the decision, and to understand the content of this decision, we must understand also the nature of the Article 1723 of Brazilian Civil Code, considering a constitutional analysis. Let's read about the content of this article that I've tried my best to translate in English. The stable union, or the stable partnership, as you prefer, it's a union between man and a woman, and it is recognized as a family entity configured by a public, continuous, and lasting coexistence, okay? And it is established with the objective of forming a family. This is content of the Article 1723, which are under discussion of those both cases that I've mentioned that we are studying right now. Well, what is the problem? What is the matter? Stable union, it is the freely translated institute translation for English, Portuguese for English, okay? The stable union, or the stable partnership, it's not new on family law here in Brazil. There is decisions of stable partnership are being recognized as so about 70s or even earlier, okay? There is a law about civil partnership, union, stable partnership or stable union. There is a law over 1991, if I'm not mistaken. And the stable union, it is usually applied for union between a man and a woman, as it is defined by this article of our civil code. Our civil code goes for 2002, okay? This is, as you can understand, this is quite the central problematic of this article. Union between a man and a woman. This limitative analysis of the article was under the scrutiny of our Constitutional Court, and it was decided on May 2011 that this kind of limitation, a man and a woman, does not get in the best sense of our constitutional isonomy, our constitutional equality, and it is incompatible with this ideal. And for this reason, from this judgment so far, there is an determination of our federal court that unions between same-sex and unions between a stable union between same gender are indeed allowed. Okay, this is quite important because despite the fact that isn't in a specific law, there is a decision with the same effects of a law applied to everyone here in Brazil. Okay, keep this in mind. Okay, stable union, it's not civil marriage. The civil marriage was decided not by STF, but was decided by CNJ for administrative purpose, because CNJ regulates civil law marriage and civil law normative. Okay, CNJ decides on May 14, 2013 that it is allowed same-sex marriage for the same funds. So once more, for a judiciary branch system organism, there was a normative, there was a decision that allowed a civil, that allowed a same-sex recognized right. And this is quite something to understand how deep is Brazilian law system over, unfortunately, the law and the legislative process itself. It is a quite of criticism here that I'm making, because legislative, it's too much sometimes, too much slow to decide to establish new laws that that accomplish the will of the society. Okay. Well, this is the first case that I'd like to share with you. Let's continue. Moving on, the next case that I've selected for you for this class, it is 80Y35, judged by STF on May 29, 2008. The main objective of this act, in particular, it is the constitutionality of embryonic stem cells research. The biosecurity law, Brazilian biosecurity law, allows research on stem cells, okay, but in some conditions with some respects, and this allowance was the constitutionality of this allowance was questioned by some citizens and some groups and some actors, religious and philosophic actors who does not agrees with this kind of research, considering that this may or should or shall be some aggression, some kind of aggression on human life. Okay, so in one hand there is the principle of human right, human life, and when does this begins to be qualified as life? And in the other hand, there is some major advancements on human health, human dignity, and human society for all instances. And this kind of debate was on the topics on the agenda of this particular act during this judgment. On this particular act, was decided that naturally embryonic stem cell research was indeed constitutional, but there is some limitations that was implied by the law, by our biosecurity law, and it still must be respected by researchers. I try my best once more to translate this to English, the Article 5 of our biosecurity law, and it is something like that. It is permitted, it is allowed for research and therapy purpose the use of embryonic stem cells obtained from human embryos produced by in vitro fertilization and not used in respective procedure, provided by the following conditions. Okay, first, are not non-viable embryos, or are embryos frozen for 3 years or more on the date of a publication of this law, or which are already frozen on the date of the publication of this law after completing 3 years counted from the date of freezing. But any case, the consent of the parents are required, and the approval of the respective research ethical committee, it is mandatory. And of course, in Brazil, it cannot be any biological material cannot be sale. It is a crime. It is a felony. Okay, and so considered by our court, our constitutional court decision, human life begins when the embryo gets fixed on the uterus wall. Okay, and this embryo begins continuing with the cellular multiplication and get fixed in 1, 2, or more individuals. Okay, I'm talking about natural Gemini process. And this is the mark, this is the great instance for the beginning of the life for Brazilian law to be considered as one viable or more viable individuals. Okay, get this in mind. All those thematic, all those medical and biological thematics was discussed on this ADY judged on May 28, okay, 2008. I'm so sorry. And it's kind of revealing how does a lawyer, how does a student of law must to get in touch with some medical thematics, some biological thematics, and must to understand at least a little bit of all those thematics. How our constitutional law quite rich in content, in horizontal content, considering all other ramifications of our sciences, science of law. Okay, this is something that I always like to share when I talk about these matters. Okay, naturally I'm talking about constitutional law with civil law implication. Okay, moving on, the next case that I've selected for you, it's the case. It's not a full case. I'm bringing to you once more some particular case, the case that I have numbered here 2.5, okay, half. And this particular case, the ADPF 54, judged by STF on April 12 of 2012, okay, was dealing with anencephaly abortion. Okay, it is a criminal and a felony was judged by STF. It is indeed not a civil law matters, but it is kind of connected with this thematic that we are exploring just right now. Okay, once more, STF must face some major aspect of biological thematic, medical thematic, must to understand these matters to renew, for this, to say the least, to renew Brazilian law, to reinterpret Brazilian penal code on this case. And once more, as you will see, STF must to almost, I can say for sure, more than almost, create a new law considering these particular circumstances. Okay, let me clarify to you how does this happens. Okay, first, Brazilian penal code, Brazilian criminal code, it is from 1946, if I'm not wrong, and I guess I'm quite sure about this date. Okay, so it's kind of old law. naturally, from 46 to now, we are in 2020, okay, there was some major additions and some subtractions of this law, naturally, okay. It's not the very same law from 14.6, but it is quite the same essence, okay. And this penal code established two hypotheses of legal abortion. The first hypothesis, in the case of rape, women get raped, and this particular woman can make an abortion without any criminal consequences against her. Okay, this is the first circumstance, the first hypothesis. And the second hypothesis, it is when this woman get her life in dangers with this pregnancy. Okay, so this is the two legal abortions legally made by Brazilian law, Brazilian criminal law. Okay, but when this act go for STF to judge, there is a attempt to accept some new thematic, some new hypotheses, considering some particular cases that was happened during the last few years or while. I'm talking about naturally anencephaly cases, okay? To clarify to you, when this baby with anencephaly is born, he or she will not endure much more than a couple of hours, precisely because of the lack of the brain, okay? So this kind of event was bring to this act that was judged by STF, and STF considered by all those arguments that this is a third legal hypothesis that women can get an abortion without any criminal consequences, okay? This is not the very text of the law. I will repeat that, okay? But there is some inception of this interpretation of this case, of this hypothesis, considering all the context that I've explained to you just right now, okay? So STF considered this hypothesis as a legal abortion hypothesis, and now a woman with this kind of situation can make legally an abortion, despite the fact that there isn't precisely predict on criminal code, on Brazilian current criminal code. Okay, this is the next case that I bring to you. Well, continuing on, we have the third case that the official third case that I like to share with you, and this third case deals with personality rights and legal person, okay? Some major distinctions bring by civil law. Let me explain this matter to you, and then we're going to see an ADY 4815 for more elucidative purpose, okay? Now we're going to establish the difference between personality rights and legal person rights, okay? Those two are quite important for us to understand all the complex of this people rights, okay, this kind of civil rights. And the first, personality rights, we can establish the beginning of the personality rights when there is the beginning of the life considered by naturally standards established by Brazilian law in all means, okay? We just established that on a few minutes ago, okay? And this kind of matters, it is when does the life begins, when does the personality rights begins, also. From that point on, there is a prohibition, there is some implications on any attempts on these individual rights, okay? This is quite important. But for financial purpose, for patrimonial purpose, this individual does not get any rights, not until he is born with life, with his first breath with life, okay? So when this individual get born and breathe for the very first time, this individual with this breath, he also received these legal person rights, okay? This is quite something to understand, because now on the judgment of this act, this ADYN 4815 judged by STF on June 15 of 2015, there is some matters that relies on personality rights, okay? And this difference between these two institutes, it's kind of important to us for us to understand this case, this act, this ADY 4815 judged by STF on June 15 of 2015. I'm talking about non-authorized biographies, okay? This matters happens when some famous singer in Brazil move an act against someone, some writer, who tries to and who indeed written some non-authorized biography about him. And this naturally goes on STF, and STF decided by all means that even with personality rights, even with the right of intimacy, the facts that this writer collected for this biography, non-authorized biography, the facts are all public. So this singer, this person, does not have the authority, does not have the capability to avoid publication, to avoid this non-authorized biography to be published. Okay, this is quite important because in one hand there is, as I mentioned, the right of intimacy, and on the other hand there is the freedom of speech itself. And in these matters, freedom of speech wins on this question considered this intimacy right, this personality right. This is some interesting to realize, and I'd like also to hear how does this happen there in Poland. There is some similar institutes there in Poland, Professor Łukasiewicz. What does you say?
The legal system in Poland.
Yes, of course. In Poland, it's of course also obvious that writing biography of famous person without her agreement is something like interfere in her rights. However, in Poland we have a lot of cases of books about someone, and of course the most popular situation is when a person authorizes it. Okay, for example, famous singer or actress or someone who is, or for example, sport person. But the most problematic is a case of well-known person who are not really happy that someone write biography about himself or herself. So I think that in Poland, of course I'm not specialist in this area, but I think that generally speaking we use here a general framework, especially connected with compensation law. For example, if you write a biography of a person without taking true facts into consideration and basing only on, for example, some information which haven't take place in fact, you have to be aware that maybe a famous person will sue for something. I mean, for compensation. So I'm not specialist of this field of law, but probably we use here general acts. Of course, we have some legal regulations which specifically regulate this matter, but I've never do any research about it, so I don't want to answer the question specifically, because I don't want to make any mistake, honestly speaking. But as far as I know, we use in this field general regulations.
This is quite interesting, my dear friend, indeed. Well, my dear friend, we are now reaching the very end of our class, and I'd like to share the least slide that I've select for you with the last case that I've select for you. And now you can see this is indeed some delicate matters for us Brazilians. Still nowadays it is. It is a delicate point because it deals with racial heritage, it deals with social disequality, it deals with social rights, it deals with human dignity, to say the least, okay? This is some matters which are still on debate by everyone on the society. And what is the big deal with this question? There is a quota system used by universities in Brazil to allow Black persons and to allow indigenous persons to gain access on these universities. There is a quota about 30%, but this can be by any number, and this quota it is dedicated to Black people and indigenous people, okay? Some major points of this. First, the first problem, it is the racial aspect of this quota system shall or should be the only one. I mean, there is some quota system only for the Black person and the indigenous person without considering, for instance, where does this person came from. It is quite important for me to clarify to you the Brazilian reality, because Brazilian, unfortunately, Brazilian high school and Brazilian public school, it isn't the best school indeed, okay? It isn't the best school indeed. The best schools in Brazil are most of all private school, okay? And this private school in Brazil, all the private school here in Brazil in general, are so much better than the public school in general. To clarify, the public universities here in Brazil are very much better than the private universities in general, okay? But in the case of high school and school, private schools are much better than public schools, okay? So when does an individual are considered singularly by its ethnicity? It is quite adequate to does not consider this individual past, when or where does this individual studied, which opportunities this individual get during his life. Well, this is some quite debated matters, okay? This is the first. And the second point that I'd like to share with you, the second, I guess, delicate problem that I'd like to share with you. It is the self-declared ethnicity, okay? And for the result of this act, it was decided that this public policy, it is desirable, okay? It is desirable that universities shall establish some quota system to allow Black students, allow indigenous students to gain access on these universities, consider all the slavery years, consider all the atrocities committed on the Black persons and committed on the indigenous persons during Brazilian history, okay? So this is a necessity on the universities here in Brazil. There is some necessities also to be appropriated on this system, but the system must to exist to try to redeem some mistakes that was made on the past. Okay? So we are now reaching the very end of our class. Once more, my dear friends, I'd like to say thank you to you all, and I'd like once more also to express my gratitude to my dear friend Professor Łukasiewicz. Thank you very much. I'd like to share with you, as you can see right now, I'd like to share with you 2 links. And these links, one is if it is Brazilian constitutional in English, okay, and the other STF for your researches of our major decisions, okay, both links in English so you can identify more easily, okay. There is my email if you want to write something to me, if you have any doubts. I am all ears for any questions. Thank you very much. Thank you, my friend.
Thank you very much for very interesting speech. Of course, I don't have questions. I have some remarks. I think that Brazilian system is that mixed model of state law and common law, but of course with the advantage of traditional system. I mean, traditional Portuguese system, I mean state law, civil law. I think that sometimes the state law with some elements of common law is popular in these countries where the reception of law occurred. For example, in Japan, where state law was taken from European countries, especially from German, and it has been mixed with some common law elements after reception of American law. So, for example, Polish system is unified, meaning that it's a typical state law system, but in some countries it's not as obvious as in Poland. Regarding homosexual marriages, it's quite a popular situation in which some rights and obligations, typically for heterosexual couples, are empowered to same-sex couples by judgment. Of course, usually step by step, of course, from some specific rights, such as, for example, right to be co-tenant or right to compensation after partner's death, to more general rights, for example, equal position between heterosexual and homosexual partnership, or even between marriage, regardless gender. And Thiago, thank you about mentioning about abortion law, because as you know, this matter is lively discussed in Poland now after a very controversial judgment of the Constitutional Tribunal, which almost banned abortion in Poland. I think that, of course, this topic is definitely interesting, but I think that we should organize another meeting because, of course, we know different approaches different values about this delicate issue. And I think that maybe it would be a good starting point for discussion in the future. And regarding your question during your lecture, I checked meanwhile, and as I mentioned, generally speaking, we have very general regulations concerning this matter. I mean, about biographic books or films, movies. If the document, I mean film, I mean video, I mean paper, I mean article, I mean of course book, showed the sphere of famous person's private life previously undisclosed by him or her to the public, then we could use some general provisions. I mean, firstly, Article 81 of the Act on Copyright and Article 23 and 24 of the Civil Code. According to the first provision which I mentioned, this behavior could be treated as unlawful dissemination without the consent of the person concerned and who was mentioned in a film or in a book. Another legal basis is Article 23 and 24 of the Civil Code that gives the protection of privacy. So it's also very, very general protection. In the case of commercial film or book, the matter is not so simple because the doctrine argues that the exception enabling the use of image of the public figure without its consent should be limited only to the information function. But what information function means? It's not, very simple to answer this question, because if we take into consideration situation of famous singer who really often take part in event with social media, who take part in Facebook, who upload her private photos, who tell people in interviews about her private life details. It's not very, very, very simple to answer the question how far also could go with describing life of that person. So this is my answer for your previous question. So thank you very much, Thiago, for a very interesting lecture. Maybe my students have some additional questions. So if you have any question, don't hesitate to ask our guest.
Bye-bye, my friend. Thank you very much.